for those who want to have a copy and also for our records. And let's get started. Today's session is the beginning of our law symposium for the spring and summer sessions. And as you know, we do this twice a year in the spring and in the fall. And we have several presenters. Our session today begins with our first presenter, which is going to be on the topic of state of law, bad faith negotiations, the pitfalls and implications of negotiations gone wrong. Our presenter today is Louis Samuel from DG Chait. And Louis is a member of the board of directors and the head of litigation sector and the head of the commercial litigation team at DG Chait. His practice focuses on real estate and real estate litigation, and his clientele consists primarily of real estate owners, developers, and brokers. Over the years, he has developed unique advocacy skills and handles a wide array of disputes pertaining to estates and estate liquidation, including disputes involving liquidators, administrators, trustees, and heirs. Louis is recognized as a leading lawyer in commercial leasing law by the renowned Best Lawyers in Canada Legal Directory. He shares his real estate knowledge at various conferences and training sessions accredited by the Barreau of Quebec. And we are very honored to have with us today Louis Samuel from DG Chait. And I'm going to just ask for your indulgence as I allow a few more people in. And let me share, and let me get you, Louis, let me just make sure you're there.
I'm here.
Raise your hand.
Can you hear me? You hear me well?
Wave your hand. Wave to me. There you go. Okay, perfect. All right, and let me just see. Okay, perfect. So we're ready to start. And for all of you today, I would appreciate if you could leave your cameras on. I know it's something that people don't like to do on Zoom. People are very Zoom shy, but our presenter is on camera, and I think it does help for us to have a better feeling of interface. And we look forward to the days that we get back together in person, and hopefully that will come soon. But in the meantime, let's be as interactive as possible. So ladies and gentlemen, without further ado, it is my honor and pleasure to introduce Louis Samuel. Thank you, Louis.
Thank you very much, Laura, for the kind introduction and your kind words. And thank you as well to Chabad Westmount and Rabbi Shanowitz for organizing and staging the symposium. It's very much appreciated, I'm sure, by everyone. I'm very happy to be here to share and to have the opportunity to share my reflections with respect to the concept of good faith, principally as it relates to the negotiation process. The title talks about the negotiation process and its pitfalls. And when one speaks of pitfalls, I imagine, in my mind, one speaks of ultimately something gone wrong, meaning litigation. So in my mind, just so that I can share with you a bit how the presentation is going to pan itself out by way of introductory remarks, I decided to essentially look at it backwards. And I started to look at how the courts have dealt with the issue of negotiations gone wrong, realizing obviously that negotiations happen at many different stages in the course of a relationship between two parties, contracting parties. And this is why ultimately I decided to track and follow the language of section 1375 of the code, which you have, I believe, on the screen, with article which I'm sure everybody knows. It says that the parties shall conduct themselves in good faith, both at the time that the obligation arises, at the time of its performance, at the time it is performed or extinguished. So essentially, I tried to reverse engineer the presentation. I broke it up into three parts, which are the three parts that are referenced in 1375. Tried to share and prepare with you some practical considerations, always tying it into the issue of the negotiation. You'll see from the PowerPoint that I'm going to be referencing a number of judgments. Try to keep it as limited as possible. There were a couple of very important judgments, which I'm sure you all know, including the one from the Supreme Court in Churchill Falls, where I'm going to be quoting a number of passages which are very important. Essentially, I think that I'm not surprising anyone by saying that the issue of good faith is extremely vast. It's extremely large. By no means do I pretend that what I'm going to be sharing with you today is in any way exhaustive or close to dealing with the situation at large. We can talk about this for days. I try to break it up into as many parts in order to then go on and share those with you by applying them to some practical considerations. Also, the judgments, and just so that you know, I'm here with Ms. Pamela Barak, who's our stagiaire, and I'd like to thank really very much for having helped prepare. She did all the research, prepared the PowerPoint, and is going to be helping me today by sharing the different slides. I'm going to try and stay as relevant as possible with respect to the slides. Obviously, for those of you that do litigation, you know that when judgments are rendered, judges rely on a number of things as a confluence of all kinds of events. So it's very hard to really compartmentalize it into specific cases, but I'm going to try and stay what I would call slide relevant, so as not to move around too much. And you'll see as we go along that I try to break it up into different concepts that are more digestible, because as I said, the concept is very large. So we're going to begin. And by the way, before I start, I know that this is being recorded, but to the extent that anybody would like to have a copy of our PowerPoint or a copy of the cases as underlined, and what you don't see, which is what I have, is I have the benefit of a summary that Pamela prepared for me, which is attached to every case. So if anybody is interested in having a copy of those materials, to the extent that it can help any one of you, it would be my pleasure to provide them to you. And Laura, maybe we can talk afterwards about how that's going to happen, whether I send this over to you or people communicate with me directly, whichever works best is fine by me. So as far as the methodology, what I propose we do is we start with the concepts, and you have the slide here in front of you, and then we're going to move into the application of the concepts to each one of the three stages that we looked at before, which are provided for in Article 1375 of the Code. So the first thing that I want to share with you is the fact that initially the concept of good faith was qualified as being the antithesis, if you will, of bad faith. In other words, good faith was interpreted as being anything that is not in bad faith. And it was, if you will, a way of eliminating conduct which was considered to be intentionally malicious. But since then, there's been an evolution, if you will, whereby it is no longer necessary, and the judges and the cases and the case law has moved towards a definition which is more objective, which doesn't need a demonstration of a person being to have ill intent. In other words, somebody can be, if you will, well-intentioned, but still breach their obligations of good faith. So we move towards a more sort of objective definition of what is good faith. And if you'll allow me, I'll just, Pamela, if you can go to the first case, which is the one of Bloom Lucie versus Lirange. I'm going to be referencing paragraph 55, so all of you can have a look at it. It talks about the good faith being an objective norm, and it talks about une norme de comportement acceptable. It says, la bonne foi est donc devenue l'éthique de comportement exigé en matière contractuelle. Elle suppose un comportement, that's at 55, hein? Elle suppose un comportement loyal et honnête. On parle alors d'agir selon les exigences de la bonne foi. Ainsi, une personne peut être de bonne foi au sens subjectif. In other words, the person thinks that they're acting properly. C'est-à-dire ne pas agir de façon malicieuse et agir tout de même à l'encontre des exigences de la bonne foi, soit en violant des normes de fortement objective et généralement admise dans la société. So clearly what's been happening is that as the case law has evolved, it's moved towards an objective assessment of whether or not a party has complied with its obligations of good faith. And that obligation essentially is divided into two large groups. There is, and we'll see it afterwards, it's divided essentially between a duty of loyalty, in other words, to act honestly, and we'll get to that a little bit more in detail later, and a duty of cooperation, which itself has its own subcategories, which is a duty to inform and as well as a duty to see to the fulfillment of the obligations provided for in the agreement. Interestingly enough, and this is something I want to share with you, and this is probably the first part where I'm going to be quoting extensively from some of the cases, is that I found it interesting when I was reading the authorities, is that the concept of good faith is often articulated as being the glue, if you will, or a relationship between issues of equity, morality, and the law, which is very interesting. So I'd like to first go, if you will, Pamela, to again set the same judgment at tab 1 at paragraph 108. And I find it interesting because you'll see later on when we talk about negotiations and what essentially has or should transpire in the context of negotiations, one really needs to always keep in mind the issue of concepts of fairness, morality, and equity. So at paragraph 108, which I believe you should be seeing there, the judge references there the author Vincent Karim that we all know, la règle de bonne foi codifiée à l'article 1375, ne laisse planer aucun doute. Quant au lien existant entre la morale et le droit des obligations, puisque la bonne volonté morale est intimement liée à l'application de l'équité. So they're very interesting concepts here that we'll see later transcend the actual issues or content of a possibly written agreement. La bonne foi est une notion qui sert à relier les principes juridiques aux notions fondamentales de justice. As well, in the case of Singh versus Kohli, which is a second case that we'll be looking at a little bit more in detail later, Pamela, if you can go to paragraph number 68, at the top of page 26, again, this is a judgment, a relatively recent judgment of the Court of Appeal of 2015. And the court talks about at the top of the paragraph on the next page. Yeah, if you just go to the next page. Yeah. So about 4 lines down, il faut alors départager le royaume de la liberté contractuelle, we'll get to it later, et celui de la moralité contractuelle, véhiculé par les principes de bonne foi et d'équité. On ne doit pas tromper la confiance légitime d'autrui, and we're going to get to that later on this issue of essentially acting in a way which takes advantage and misleads the legitimate trusts of others. There is also another reference I'd like to share with you, which, Pamela, that's the one of Churchill Falls. It's in tab 7, paragraph 104, which I find quite interesting. And I apologize if sometimes I'm just reading extracts, but I find that really it serves no purpose to quote unquote reinvent the wheel. Some of these judgments articulate the concept so well that I think it's much more efficient for me to simply share with you some of these passages that I've highlighted as being really the ones that are most relevant. And here I'm talking about paragraph 104, if you can get to that, which talks in very broad terms and is very interesting. And this is an important perspective, not only, and I want to just maybe go off on a tangent to share with you the following. When one talks about good faith in the context of negotiations, that's all well and good, but ultimately, if someone, as I mentioned before, talks about negotiations gone wrong, ultimately somebody's going to end up in front of a judge or an arbitrator, clearly. So it's very, very important to understand how a judge, Court of Appeal, Supreme Court, whatever, would have a look and assess the situation depending on the circumstances, obviously. And the concept is a very, very broad one. If you look at paragraph 104 that we have on the screen, it says good faith confers a broad, flexible power to create law. Talking about the articles we looked at, these articles and their location in the code suggest that the court should infuse this concept into the whole of Quebec civil law. The commentary of the Minister of Justice at Article 1375 leaves no doubt as to its potential scope and its capacity to change the civil law over time. A little bit later, it says it's a concept that serves to connect legal principles with fundamental concepts of fairness. And a little bit further down in this paragraph, understood in this way, good faith is more than a series of distinct obligations. It is instead a broad principle that should be applied flexibly, having regard to the particular circumstances of each case. So, I mean, it is clearly based on these extracts, an overarching obligation which applies to the entirety of the relationship between the parties. We'll see a little bit later when we talk about the issue of the obligation of good faith as it relates to the negotiation process, which is pre-contractual. There's a very important distinction that I'm going to get into between the right or not to contract versus the actual negotiation process itself, which is the sandbox, if you will, within which the concept of good faith applies. We'll see later that the concept of good faith can't be extended to obligate somebody to contract or to sign an agreement, although the cases are clear that once you've engaged in a good faith negotiation process, and the longer that process lasts, and the more there's a relationship of trust and confidence that's established, it becomes that much harder to walk away from the discussions. That basically, if I can, sort of summarizes the intro. What I wanted to share with you is with respect to the obligation of cooperation. I mentioned before the duty to inform. There's also, I forgot to mention, the obligation to facilitate the execution of the contract, which is a very, very interesting concept, which we're going to get into later, which is really the party's obligations, a party's obligation, if you will, to cooperate, to dialogue, to find solutions, to essentially negotiate to the extent possible solutions to problems that can be encountered during the life of a contractual relationship between two parties. So it's quite vast, as you can see, and I can't stress enough the fact that it really is an overarching fundamental and a governing principle in terms of the relationship between parties to a contract. So let's first then now talk about good faith within the context of the negotiation of an agreement. If we can go to the next phase, yeah, that's the one. So the first principle that I'd like to share with you is the one having to do with what I just talked about before, which is the freedom to contract. And if we can go back to the case of the second case of Singh versus Kohli, I'd like to share with you paragraph 66, which I think is really sort of the starting point and the governing principle from which the whole concept of the obligation of good faith will flow. And it says this, is at paragraph 66. Freedom of contract as a demonstration of free will, which entails freedom not to enter into a contract, is the rule. In and of itself, refusal to enter into a contract is not considered blameworthy, and no personal liability may ensue from such a refusal, whatever the reason may be, except in circumstances which are not, we're talking about the specific case. Later on in paragraph 68, at the top of the next page, actually, the second paragraph. En règle générale, la liberté contractuelle permet à une partie de se retirer des pourparlers quand elle veut. Elle lui permet même de mener parallèlement des négociations sur le même projet, I'll get to that later, avec un ou d'autres concurrents sans le divulguer, à condition de ne pas mentir à ce sujet et de ne pas s'être engagé à négocier exclusivement. A little bit further down at paragraph 70, the Court of Appeal in this case quotes the case of France Film versus IMAX, which is often quoted. And the principle is set out at the bottom of the page. L'obligation générale de bonne foi dans la formation des contrats n'impose point de droit, n'impose point de ne pas rompre les pourparlers. In other words, does not obligate one not to terminate discussions, mais elle commande de ne pas y mettre fin sans justification lorsqu'on a suscité chez le partenaire la confiance dans la conclusion de l'accord. And then further on at 71, this often cited sentence must be read in context, however, and it's worth repeating that except in circumstances which are themselves the result of freedom to contract or not, no one has to enter into a contract or make a promise to contract. 2, that there is a correlative right to terminate negotiations. That such negotiations are generally undertaken with the anticipation that a contract will ensue does not mean that one party cannot change his or her mind along the way, even at the last minute. Good faith in that sense is not meant to limit freedom to contract or not to contract, but to ensure the parties act honestly and loyally during the process. And that really is the key here. The key is that depending on where one is situated in the process, initially, and there are some other passages that I'll make reference to, there is no obligation to enter into a contract. But the reality is that the law obligates a party that's engaged and that decided to engage him or herself into a negotiation. Once that person has negotiated, even if they don't have an obligation to contract, they nonetheless have an obligation to act in good faith within the context of that process. So essentially, what the court says is that the failure to negotiate in good faith is not the equivalent of a failure to enter into a contract. What's prohibited, excuse me, is to mislead the legitimate trust and expectation of others. And that, as you saw from some of the passages that I already quoted, is a very often quoted principle. In other words, once the process is engaged, one needs to be very mindful and careful about how that process is managed and ultimately, if the case be terminated, especially if there's a level of confidence and expectation that's being created by the discussions between the parties. And we'll see a little later, the longer the discussions, the more money spent, the more in-depth the discussions, the nature of the relationship between the parties. Do they know each other for a long time? Have they done business before in the past? These are all factors that the court takes into consideration when deciding whether ultimately the decision by one or the other party to pull out was justified under the circumstances. And if it isn't, ultimately decide whether or not there's a recourse to be had by the party that was frustrated in the negotiations. So again, when talking about this concept of the issue of not breaching the other party's trust, if you will, I apologize. There's the issue of as the negotiation goes on, as I just mentioned to you, the longer the negotiations, the more serious the reason has to become, and that's where it becomes, I think, a very fine line to cross. And sort of in keeping with the title that we have, when negotiations have gone wrong, I mean, that's ultimately, I think, really the issue that's before us today, right? Is where do you draw the line? And at what point can somebody just walk away from a negotiation alleging or contending that there really is no possibility to make a deal? And there are a number of cases, we'll get to them in a second, where parties and the judges have decided based on the evidence, and I don't think it's going to serve any purpose for us to go into the specifics of the case. Every case obviously is judged on its own merits, but essentially the courts are very mindful of attempts by parties to use pretexts or subterfuges in order to walk away from agreements or negotiations, and they can take any kind of format. They can insert themselves in the context of negotiations having to do with the satisfaction of a due diligence, compliance with conditions that are conditions precedent to a contract, pretexts having to do with not wanting to transact with respect to the purchase of a property because of a slight defect in title that could otherwise be remedied, and the party refuses to engage in meaningful discussions in order to rectify that blemish. I mean, there are an infinite number of permutations and combinations that can exist that could ultimately lead to a court deciding that a person was justified or not. But suffice it to say that what's important is that if, and we'll get to that a little bit later when we're talking about the negotiations and avoiding the pitfalls, if there is a possibility for the parties to work out a settlement, to work towards a solution, what these principles provide is that they have to deploy their best efforts, and they have to do what they can with a view of arriving at a solution. That being said, the opposite is also clear, namely that a party can put an end to negotiations which are going nowhere and are doomed to fail. But again, it's very important that before one proverbially pulls the plug on a negotiation, that all the efforts have been deployed with a view of making sure that everything can be done. And to share with you a situation which I'm living now, I won't share any names, but I'm sure that all of you have shared this. For those of you that do real estate, we have a situation regarding involving a purchaser who's just not complying with the terms of his offer to purchase, of his promise to purchase. He's not complying with the conditions. He's not complying with the proof of funds. He's continuously delaying the situation and delaying the closing. And I told the client what I'm sharing with you today is better to err on the side of caution, better to paper your file and to try and find a solution with the buyer to make sure that we can ultimately close, as opposed to take advantage of any slight pretext in order to walk away from the transaction. Because ultimately, if one acts too quickly and doesn't act in a way which is fair in keeping with the circumstances, in this case, for example, the purchaser may ultimately, for example, issue conveyance proceedings and the whole thing will end up going sideways. Now, in terms of the possible claims that could arise, if you will, in the event of a breach of the obligation to negotiate, if you will, in good faith, well, there are a number of possible consequences. Party can claim their hard costs, their loss of time, their loss of business opportunity, an impossibility to execute a contract with a third party, a loss of profit, although that is a very difficult thing to establish. And on this, I refer you, I go back again to the Court of Appeal judgment in Singh. If you can go to paragraphs 90 and 92, where those different elements are mentioned by the court as being potential claims. But when one reads the judgment a little bit more carefully, it becomes clear that the threshold in order to be able to claim damages is very high, because the court considers, and that's at paragraph 92, that there is a, if you will, a ordinary risk associated with any negotiation. So again, looking at paragraph 92, at the third line, court talks about the inherent risk of any contractual negotiations and can hardly be considered a prejudice for which compensation may be obtained except in the most exceptional circumstances. So thinking back to the concept of negotiations gone wrong, right, that sort of attaches itself to the threshold as it relates to what is fair and what is appropriate and what ultimately can be claimed once a person decides to no longer continue with the negotiations. In other words, what the court says here is that there is an obligation to negotiate. There's no obligation to do the contract, but once you've engaged in the negotiation, that's all well and good. You have to act in good faith, but ultimately, you don't have to overly concern yourself with respect to damages to the extent that the cratering of the discussions intervene further to a quote unquote good faith negotiation, because there are inherent risks in any negotiation. That being said, I wanted to point out something from a substantive standpoint, to the extent that it may be of interest to some of you, that because we're talking about the obligation of good faith within the context of the negotiation of a contract, it necessarily obviously implies that there is no contract, unless there is ultimately some sort of pre-contract, like a promise to purchase or something that is executed with a view of concluding a second contract. But presuming that there is no contract, it means that we're not within the realm of a contractual relationship, so that the liability for someone who does not respect his or her obligation to negotiate in good faith is an extra contractual liability, not a contractual liability. Okay. So as far as this first component is concerned, if I had to share with you any conclusions or recommendations, I would most certainly say err on the side of caution. Transparency is your best friend, obviously not to the point of jeopardizing your client's strategy or position. Go to the extent possible above and beyond the line of duty and be as specific as possible. I'll give you examples that I've encountered both in the context of negotiating agreements as well as in court. Oftentimes I see offers to lease with references that the parties will engage or sign the lease at a further date, which is, again, a problem to the extent that the offer contains all the essential stipulations of the agreement. It means that the parties have an obligation to negotiate in good faith a lease agreement. If it doesn't end up getting done and the negotiations and discussions derail, more oftentimes than not, people end up in court. So, for example, on that account, I always recommend to my clients to always either attach a standard form lease or to make their offers as comprehensive as possible. So to avoid open-ended clauses, that also applies, again, in landlord-tenant matters, which I do a lot of, to renewal options that are contained in leases that contain clauses whereby the parties undertake to negotiate a rent that is commensurate with the market value, this, that, and the other thing, always ends up potentially being a problem. And it could ultimately be a very big problem for the parties, because if those negotiations go wrong and the party accuses the other of not negotiating in good faith, it's very simple at that point in time to end up in court and asking for a judge to decide what the rent will be or what the conditions will be. And obviously nobody wants that. A short aside on the issue of the duty to inform as part of the obligation to act in good faith in the pre-contractual stage. I want to just very quickly talk about this because there is a whole body of law that deals with the issue of the obligation to inform, and I won't get into it because it's quite vast in and of itself. Oftentimes it applies to construction contracts for those of you that do construction work, construction law, calls for tenders by the city, by cities, by public bodies. And I quoted one judgment, which is the city of Sherbrooke that you have there on the screen versus Shermax. And the interesting thing about this case, just by way of an example, as an example of a negotiation gone wrong, if you will, or a failure to inform as part of what the court would consider to be a good faith pre-contractual negotiation with a party. In this case, there was a call for tender, and in the tender documents, the city of Sherbrooke stated that as an indication, the reservation requirements for the center's field that was supposed to be built was a certain number of hours. And then after the, I'm sorry, and then the party relied on that representation in order to submit the tender, because there was a clause in the contract that also guaranteed a minimum revenue of $400,000. And then the court came to the conclusion that the city failed to meet its obligation of information, cooperation, and fairness by issuing a tender, knowing that the organizations would require subsidies in order to rent the center for the estimated hours. In other words, it was calling for tenders in conditions where it knew full well that there would not be sufficient cash flow in order for it to meet the threshold of profitability. Also, and then obviously under those conditions, the court held that the city was liable. So, and held that the city was liable. Why? Because within the context of the negotiation process, which is the call for tender, whether it took place in the context of a classic negotiation or whether in this case it was done by way of a call for tender, that the city didn't act in a transparent and forthright manner. And on this point, I'll refer, and Pamela, if you can go to paragraph 86. Again, the court talks about l'obligation générale de bonne foi engendre notamment une obligation de renseignement à l'étape pré-contractuelle, again, before the contract is signed. And then further down in the quotation in paragraph 88, citing the case that everybody knows of Banque de Montréal contre Bail, the paragraph that talks about l'apparition de l'obligation de renseignement est reliée à un certain rééquilibrage au sens du droit civil. Alors qu'auparavant, il était de mise de laisser le soin de chacun de se renseigner, de s'informer avant d'agir. Le droit civil est maintenant plus attentif aux inégalités informationnelles. Elle impose une obligation positive de renseignement. So remember that whenever you're negotiating or parties are negotiating or you're representing somebody who's negotiating, to the extent that that person has information that is relevant for the negotiation, I think that it's important that it be shared with that party, failing which it could be held that your client will be offside in its negotiation and therefore liable for the damages resulting from its lack of transparency. Paragraph 90, a little bit further down, there's also mention about the issue of the fact that a party can rely on the other. There's the concept of reliance on the fact that a party should be able to rely and expect that the other party has fully and completely shared all the information that would be relevant for the purposes of the contract. So I just want to talk about this very briefly. There's an obligation of reliance, which is a sort of a side issue to the obligation of good faith, which talks about the obligation to act in a loyal and transparent fashion. So always be very careful. Again, trying to sort of reattach it to the issue of the pitfalls of negotiations gone wrong. Be very mindful and careful not to be, if I can use an expression, not to be too cute, and to share the information that is relevant for the purposes of the negotiation between the parties. So that concludes the first part of my presentation as it relates to the negotiation stage. I now want to share with you some issues having to do with the second part, which is the obligation of good faith as it relates to the performance of the contract. And there were two issues, as I talked to you before. There were two sort of subsets. There's a duty of loyalty and there's the duty of cooperation. The duty of loyalty is, if you will, a passive obligation, for lack of a better term. And I'll explain why in a minute. The duty of cooperation is an active or proactive obligation, which, as I mentioned before, includes the duty to inform and also the duty to cooperate to see to the fulfillment of the contract. So the duty of loyalty essentially boils down to, quite simply, not to act in a way that is harmful to the co-contracted or could constitute an abuse of contractual rights under the circumstances. And if you'll allow me just to quote, and it's not part of the documents, Pamela, but just some examples in an article that I found about what would constitute a duty or compliance or non-compliance with the duty of loyalty. It includes as follows. Cette obligation regroupe plusieurs interdictions. L'interdiction d'alourdir le fardeau du co-contractant, l'interdiction de compromettre la relation contractuelle, l'interdiction d'adopter une conduite excessive ou déraisonnable, interdiction d'invoquer des prétextes pour terminer une relation, interdiction de créer des fausses attentes par son comportement ou ses propos, l'interdiction de traiter son co-contractant sans aucune considération minimale de ses intérêts et des circonstances visées par le devoir de loyauté. De même que l'interdiction d'empêcher son co-contractant de retirer le bénéfice espéré du contrat ou plus généralement de modifier l'équilibre contractuel. So again, more of a passive type of obligation, but nonetheless a very important one, which has to do with the fact that one must not essentially cause harm to one's co-contracted by acting in a manner which is improper or contrary to the concepts of fairness and good faith. A small aside here, when I say a small, it really isn't, because it's a very important decision, which is the decision in Churchill Falls versus Hydro-Quebec, 2018 Supreme Court of Canada decision that deals with the issue of unforeseeability. I'm sure that many of you are aware of this judgment. This is a case that was decided by the Supreme Court of Canada, had to do with the concept of unforeseeability. In this case, one party was attempting to renegotiate. Churchill Falls was looking to renegotiate the terms of contract that it had concluded with Hydro-Quebec many years before, pursuant to which it undertook to sell hydroelectricity at a certain subsidized, not a subsidized, but at a reduced rate, in consideration for which Hydro-Quebec at the time undertook a number of financial commitments and obligations. With the price of electricity that went up since then, Churchill Falls was looking to essentially renegotiate the contract, alleging that the increase in price was unforeseeable and that as a result of concepts of fairness and whatnot and of good faith, the parties were obligated to essentially revisit, if you will, their contractual relationship. First important point, good faith and unforeseeability are two different concepts altogether. And the Supreme Court of Canada in Churchill Falls confirms the proposition that the concept of unforeseeability does not apply in Quebec, except obviously if the parties provide for it in their contract, either clearly, expressly, or implicitly. There are certain contracts which are either joint venture type contracts or contracts that contemplate that parties will revisit their covenants or their relationships if ever situations change. But barring these kinds of indications or conditions in the contract, essentially a party can come and plead lesion after the fact and say, well, now it's become more onerous for me to fulfill my obligations under the contract, and therefore you must negotiate with me and do a retrade with me on the terms of the agreement. So the general obligation of good faith, it does not include the obligation to accept new conditions if there's a change in circumstance. And here I'd like to quote paragraph 107 of the judgment. If you can go to Churchill Falls, Pamela, because I think it's an important point that makes the point between the equilibrium of a contract and the execution in good faith of a party's obligations and the performance of the agreement. Do you have the Churchill Falls at paragraph 107? As Hydro-Quebec points out, because good faith serves to protect the equilibrium of a contract, these are the conditions that we looked at before, the proper fulfillment, execution of a contract, it cannot be used to violate that equilibrium and impose a new bargain on the parties. So in cases, for example, where clients come and see you and they want to engage or are engaged in negotiations having to do with some form of retrade under an agreement, whatever that may be, the concept of good faith does not obligate a party to retrade on the agreement. I'm sorry, it says it cannot be used to violate that equilibrium and impose a new bargain on the parties. Moreover, because good faith is not synonymous with either charity or distributive justice, the courts cannot rely on it to order the sharing of profits. In this case, it was an issue of sharing of profits that have in fact been honestly earned. Later on in paragraph 109, court begins by saying it will reject the argument having to do with unforeseeability and talks about equity cannot be relied on in these circumstances as its effect would then be to indirectly introduce lesion or unforeseeability in our law in every case. So you can see right away that here the Supreme Court talks about equity as not being a source or an avenue that can be used to renegotiate, and yet the courts have held that the concept of good faith does flow from issues of morality and equity. So it's a very fine line, okay, that exists between what can and can't be done. But I think that this judgment stands clearly for the proposition that we cannot, or a party cannot, in the context of a contract, ask that negotiations be initiated or concluded with a view of doing a retrade on an agreement that was already concluded. It doesn't mean, however, and we'll see it later, that if ever there's a problem, and we'll see it in Berger and other cases, that if ever there's a problem that happens or there's a difficulty that manifests itself during the course of the fulfillment or execution of a contract, that the parties don't have an obligation to dialogue and to talk and to negotiate with a view of finding an agreement. What is the extent of that will always depend on the circumstances. How far one has to go will always depend on the circumstances. Appearances are obviously very important. There's form and there's substance. But clearly, there is an obligation to deploy one's best efforts within obviously commercially reasonable limits in order to find a solution. We'll get to that in a minute. Talking now about the concept of cooperation, I had mentioned earlier that the concept of cooperation includes the obligation to inform. So that obligation exists generally. I talked about construction contracts specifically, albeit briefly. So there's a general obligation to inform, and this applies to any negotiation that exists with respect to any contracts. Could be the sale of an immovable, where there's an obligation to inform with respect to the condition of the property. Could be anything. It applies to absolutely everything. The bottom line is a party cannot withhold information that it knows is relevant to the co-contractant or to the negotiation process. And that obligation has been reaffirmed on a number of occasions by the courts in many different situations, and more specifically in that whole line of case law for those that practice in the field having to do with the construction law contracts, tender process, public contracts that are given by public bodies and the like. The second obligation, which forms part of the duty of cooperation, is the obligation to facilitate the fulfillment of the contract. I spoke about that before. It's something that is, I would say, nebulous at best. The case law, I don't know whether or not in one of the paragraphs I'll be sharing with you in a moment. I remember seeing something along those lines. Where the Court of Appeal says it's a very hard concept to define. It's a bit like nailing jello to the wall. It all depends on the circumstances of each case. But suffice it to say, as I've said it before, one thing is clear. There's an obligation to have a constructive dialogue between the parties and to try and find a solution within commercially reasonable limits. An example of that could be, for example, a franchisor's obligation to provide technical assistance to make sure that the contract and the franchise agreement is fully and properly fulfilled. And the courts have even gone to as far as curtailing a party's rights under the agreement. In other words, curtailing substantive rights as a result of the other party's failure to cooperate and to deploy its best efforts with a view of bringing about the execution and the complete fulfillment of the contract. And I'd like on this point to go back to the Churchill Falls case. If you could, Pamela, go to paragraph 103, which is something that I'd like to share with all of you, which I find interesting. It says, the Supreme Court of Canada says, the general duty of good faith also serves, this is 103, thank you, as a basis for courts to intervene and to impose on contracting parties obligations based on a notion of contractual fairness. I mean, this is quite, I mean, it goes a long way. To impose on contracting parties obligations based on a notion of contractual fairness. But while good faith can temper formalistic interpretations of the words of certain contracts, it also serves to maximize the meaningful effect of a contract and of the prestations, I'm sorry, that are for the parties, the object of the contract. In other words, again, here, the parties have to do what they can within reason to be able to bring about the fulfillment and the proper realization, la réalisation of the contract, failing which they breach their obligation of good faith as it relates to the performance of the agreement, and depending on the circumstances, can give rise to a whole different series of claims, depending ultimately on what happens, whether there's a termination of the agreement or whatnot. And this brings me to the judgment in Berder, which is a very well-known judgment from the Court of Appeal 2013, having to do with the replacement and the repair to the roof of the Olympic Stadium. Contract had been given to Berder in order to see to the replacement of the roof to the Olympic Stadium, to replace it by a fixed roof, a solid roof. Berder signed a contract with a subcontractor, DCCI. The contract was quite specific. It contained some specific clauses having to do with the fact that the contract had to be Well, first of all, it was what's called the design build fast track contract, which meant, and the court came to the conclusion that it meant that the parties had an even larger obligation to cooperate and to negotiate in order to bring about the fulfillment of the agreement. Ultimately, what happened is that there were delays that were incurred with respect to the fulfillment of the contract as a result of the discussions and suspension of the work that was the result of discussions between Bird Air and the donneur d'ouvrage, the Régie des installations olympiques. And ultimately, when the time came for DCCI to do the work, they had to do it on an accelerated basis. Costs were incurred. They ran into financial difficulty. And ultimately, there was a cratering of the discussions between Bird Air and its subcontractant, and then ultimately a termination of the agreement, and then a claim for damages, which was granted by the courts on the basis that Bird Air failed to explore all the possibilities of a proper solution under the circumstances, especially given the terms of the agreement and the schedule that was provided for by the parties. So a good example of maybe a contract-specific type of situation, but nonetheless a good example of a situation where the court came to the conclusion that because of the way the contract was drafted, because of what was agreed to between the parties, because of certain elements, for example, the fact that the contract and the work had to be completed very quickly, it created an even higher burden on the parties in order to be able to collaborate, and that the discussions that happened when DCCI reached out to Bird Air to say, hey, listen, we're incurring additional costs, we have a problem, we need to talk. Well, then the court felt that under those circumstances, Bird Air did not meet the threshold of cooperation that was required, and that accordingly, by ultimately terminating the contract and putting an end to the negotiations, that Bird Air acted improperly and was ultimately condemned to pay a fair amount of money. Now, again, what I want to stress here is the issue that when one talks about an obligation of good faith within the context of performance, it's not, the issue here is not the exercise of the right itself, whether it be a right to terminate or not. It's the manner in which the right is exercised. And here, Pamela, if you can go, we're still in Bird Air at paragraph 130. And the court talks about issues of les agissements déraisonnables de Bird Air and cites Pierre-Gabriel Jobin, that's at 130. It says, il est désormais clair que le discours absolutiste ne gouverne plus l'exercice des droits que possède une personne. Être titulaire d'un droit, in other words, the right to do something, ne permet donc pas d'en user de façon abusive. C'est là le principe à la base de la théorie de l'abus de droit. Notons immédiatement que la théorie de l'abus de droit n'entraîne nullement la négation du droit en soi, mais s'attaque plutôt à l'usage qu'en fait son titulaire. So again, back to the same starting point. The exercise of one's right, whether it be, for example, we'll see it later, the right to terminate a contract, the right to exercise other monetary or non-monetary rights provided for in the agreement. The object and the concept of good faith does not attach itself to whether or not those rights can be exercised. It attaches itself only to the issue of how those rights are exercised. And depending on the context and where the parties find themselves, there'll be a whole series of different permutations and combinations and criteria that apply. As I mentioned before, whether the parties have been negotiating for a long time, they've known each other for a long time or whatnot. So again, it's the manner in which things are done, which is very important. And when one talks about, again, coming back to the concept of the presentation, the pitfalls, just be mindful and careful. Always, I would say, err on the side of caution and do what you can in order to make sure that the rights were exercised properly. And I would also tell you, and to coin an expression that I'm sure you've all heard, perception is reality. Always think in the context of your negotiations before things really go sideways and completely in the ditch, what a judge would see and read into a situation if one was to see all the exchanges between the parties and to decide whether or not the parties were really acting in a way that they were trying to save the situation as opposed to using the situation to their advantage and in what the court would consider to be an improper way. One last point on this issue, and then we're going to hop on to the issue of the extinction, which is going to be the third and last section, is the concept of la fin de non-recevoir, also known in common law as estoppel. As you all know, la fin de non-recevoir is a means to defeat a claim based on another party's conduct. That conduct does not constitute, have to be or constitute a fault within the sens civil of the term. It can result from a party's failure to respect its obligations of good faith. And here, I'll refer you to the case of Genium, which is a 2008 Superior Court case. Pamela, if you can go to paragraph 342. The court talks about the three elements that are generally considered necessary to prove a fin de non-recevoir. And the reason why I'm saying this, and I want to share this with you, is because it's important to the extent that if you can demonstrate in the context of a negotiation that's gone wrong, that a party acted in a manner so as to satisfy these conditions, then your client could theoretically, under those circumstances, raise as an argument based on la fin de non-recevoir and estoppel the fact that the other contracting party that failed to comply with its obligations because the negotiations weren't conducted properly is essentially prevented from exercising substantive rights that are in its favor under the contract, which is a very, very important issue. And I'll get to it by way of an example in 2 minutes. So Genium provides for the three conditions. A party against whom the fin de non-recevoir is being invoked has engaged in conduct consisting of actions or words which usually but not necessarily constitute a fault. The one invoking the fin de non-recevoir has acted in a reasonable manner on the basis of the other party's conduct, and the conduct of the party against whom the fin de non-recevoir is being invoked has in some manner caused the second party's prejudice. And further on, the court talks about the fact that it can result from a failure to respect one's obligation of good faith. So again, very important to the extent that you can show that a party acted in a way, for example, to mislead another party, not to share information, to cause the co-contractant to do something or to take a position which ultimately it would not have under the circumstances, and therefore you can allege that the party acted in bad faith, whether it's in the context of negotiations or otherwise. Then there's always this avenue of la fin de non-recevoir, which could be of interest and should be kept in mind within the context of the negotiation process. I just want to make sure that I'm not. Yeah, so I just wanted to share with you, we don't need to go there, Pamela, I'll just read it, it's a very short, it's from the Novacap judgment, a 2015 Superior Court judgment. And the court says this: la conséquence du non-respect de l'obligation de bonne foi dans les négociations ainsi que de l'obligation de loyauté de coopération est une fin de non-recevoir qui peut être soulevée à l'encontre d'une partie qui veut exercer un droit. So always be mindful of that. Ultimately, the failure to comply with one's obligations within the context of negotiation, wherever that negotiation may intervene, can ultimately serve as the basis for a fin de non-recevoir. By way of a practical example, and that will be the end of this section before I quickly deal with the next section. I'm currently involved in a case having to do with a land deal where, and I won't name names, but ultimately what happened is quite simply the following. My client made an offer to purchase a large industrial property. The offer was submitted, had a 5-day delay within which to accept. The broker for the vendor said, we'll get back to you with our counteroffer. Was supposed to get back to us within the time allotted for the acceptance of our offer. As a result of an email glitch, never sent the counteroffer on time, although the broker thought that he had sent it on time. ultimately only to find out that the day before the expiry of the deadline provided for in his counteroffer, the broker and the vendor realized that the document had not been sent 4 days prior. They decided, in the context of their discussions with my client, to send the document in any event without informing my client. And this is something that happened in the month of July, right in the middle of the holiday season, without informing my client that the offer was expiring the next day at noon. Client gets the document, noon comes and goes, and right after, the vendor takes the position, gentlemen, we're now out of contract, and we're now going to sell the property to somebody else. Why? Because they had received an offer for substantially more on the property. We're now before the courts, but we've already obtained 2 interesting judgments which seem to which help our client, to the effect that, hey, this is not proper. This is not a proper discussion and negotiation between the parties as it relates to the fulfillment of your contractual obligations. Yes, there was an offer. Yes, there was a counter offer. Yes, these were discussions that were prior to the actual signature and acceptance of a promise to purchase, but there is an overriding obligation to inform and to act in good faith. And by not having informed, our view is that the vendor is stopped, is prevented from now arguing the fact that we accepted, because what I failed to share with all of you is that ultimately when we found out the day after that this is what was happening, we accepted the counter offer right away, and the vendor said, sorry, too late. And our position is that it's not too late because they were stopped. So an interesting case, a situation where the court will ultimately have to decide whether or not the vendor acted properly in the context of his discussions and negotiations with my client. I think not. I may be wrong, but we'll see what happens. But it's a very, I think, concrete illustration of this obligation to act in good faith and to disclose to your contracting party within the context of negotiations before they go wrong, information which is relevant to the fulfillment and to the exchanges between the parties. Lastly and quickly is the issue of good faith within the context of the extinction of contracts. I want to share with you the judgment of Clifton, which is an interesting judgment which has been quoted on a number of occasions. This was a case where essentially Clifton was managing a shopping center, signed a deal with Metaphor. These are ATM machines. After having signed the deal, Metaphor realized that there just wasn't enough volume and wanted to walk away from the deal. Tried to negotiate with Clifton. Clifton said, no, pay your rent. We're not interested in negotiating with you. And then ultimately Metaphor left, and Clifton sued for unpaid rent. Was not suing for termination, was suing for unpaid rent, specific performance. The tenant filed a cross demand alleging 2 things. Number one, that Clifton was acting in bad faith, didn't negotiate in good faith, did nothing to relet the premises, and asked for the termination of the lease. Well, a very good judge, Carol Cohn, one of my ex-partners, granted the action, and it was taken to appeal, and the Court of Appeal confirmed the judgment. And the Court of Appeal is of the view that the obligation to act in good faith transcends all aspects of the law, regardless of whether or not somebody's in the context of a repudiation, obligation to mitigate, specific performance, and whatnot. And ultimately, they came to the conclusion that by not doing anything, by not entertaining any discussions, by not trying to relet the space, by basically saying, hey, listen, you've got deep pockets, pay me your rent, that was a breach of a party's obligation within the context of the extinction of the obligation of the contract. I apologize. And because of that, the court capped or maintained the judgment and capped the amount of damages, the amount of rent, that the landlord was able to claim under the lease, and maintained the resiliation of the agreement. So an interesting example of a situation where a party refuses to act in good faith, even in the face of, in this case, a tenant leaving because they have come to the conclusion that this is not a financially viable proposition for them. Nonetheless, an obligation on the part of the co-contractant, in this case, the landlord, to mitigate and to act in good faith, failing which their substantive rights will be curtailed. So remember that if ever you're in the process of negotiating, whether it be in this kind of situation with a tenant or otherwise, always keep in mind that you have to try and find a solution, try and find a way in order to be able to come to terms. There could be a number of ways that this can be done. For example, in that case, I certainly wouldn't have taken that attitude. I would have taken the attitude that the tenant is there. They're still bound by the lease. I would have tried to to release, and I would have introduced tenants, possible tenants to the then current tenant, inviting them to sign a sublease, but I would have done something. Last case, and the last point before my conclusion, is the case of Bennett. This is a case that I just wanted to share with you for the simple reason that this is Court of Appeal 21. It's a recent case. Really, the case had to do with whether or not the sale of an asset caused the extinction of an obligation by Hydro-Quebec to furnish at no cost to the originating contracting party a certain amount of electricity. And ultimately, the court was of the view that the defendant, sorry, one of the parties was in error in terms of its interpretation of the agreement, and accordingly had to continue furnishing those services, but because it couldn't, was condemned to pay a substantial amount of money, close to $3 million. But the relevant portion of this judgment is that this contract that existed between the parties dated back many, many, many years. The contract dated back to 1959, if I'm not mistaken. And it may even be longer. I forget exactly the dates, but it's very, very long. And in paragraph 60 of the judgment, and I promise you this is my last reference, the Court of Appeal says this: s'ajoute dans ce cas-ci le caractère, oh no, I'm sorry, I didn't, plus que centenaire, more than 100 years, de l'obligation en cause, ce qui aurait mené un co-contractant prudent, raisonnable et de bonne foi, and there seems to be a line missing, d'agir avec prudence et choisir de discuter de la question avec son co-contractant de longue date plutôt que de mettre fin péremptoirement à l'obligation contractuelle. La doctrine et la jurisprudence sont d'ailleurs très sévères à l'égard d'une rupture injustifiée ou intempestive des rapports contractuels. In other words, here, as an aggravating factor, if you will, the court felt, and it sort of ties into what I was saying before, that in the context of, in this case, the exercise of a right terminating an agreement, or could very well be the same thing with respect to rights within the context of negotiations, the longer the relationship between the parties, the higher the burden to act properly. So in conclusion, and I apologize if I'm running a little late, because there's a bit of we'll have a Q&A if anybody is interested, but I would say this: err on the side of caution, be transparent, at the risk of using maybe a political slogan, do the right thing, do what's right, and always keep in mind, how would a judge look at this, and how would a judge perceive my conduct under the circumstances? Is it fair? Is it proper? Am I looking to use this as a pretext or not to walk away from a contract or a negotiation or not? Understanding obviously that there's no clear line other than the fact that ultimately somebody's going to have to convince the court that he or she acted in good faith and did everything they possibly could in order to either bring the contract to fruition or the negotiations to fruition. And on that note, I thank you very much for your attention. If there's anybody that has any questions or would like to share some thoughts or experiences, I'm all ears.
You could just unmute yourself, or if you prefer, you could just unmute yourself and throw in your question. Don't be shy.
I
Or you
have a
can raise your
question,
hands.
if I may.
Sure, go ahead.
If a corporation is found to have breached its obligation to act in good faith, does that open the door for a personal remedy against the principles of the corporation?
Well, that issue, I think, raises issues of you know, I wouldn't say corporate governance, but it's that whole body of law having to do with the liability of directors as it would relate to them. It raises the issue also with respect to the shareholders, as I understand it, of whether or not there's an extra contractual liability and issues of alter ego and whatnot. And it obviously, in my view, would depend on the circumstances. I mean, somebody who is the sole shareholder or majority shareholder of a company that he or she uses as a vehicle and breaches an obligation knowingly, for example, there could be the possibility to sue that person personally, both as a result of his failing to act diligently in his capacity as director, an officer of the company, but also maybe as a shareholder, alleging lifting the corporate veil or alleging that somehow the company was acting as an alter ego, and therefore that it was done with a clear intention to deprive the other party of its rights under a contract. But those concepts, as I understand them, are outside of the purview of the issue of the obligation of good faith. It's really, would that person, the shareholder or the director, be liable, taking for granted, right, that there was a breach upstream of an obligation to act in good faith pursuant to whatever agreement may have existed between the company and another party. I don't know if that answers your question. Doesn't really add very much, but I don't think that to answer your question specifically, I don't think that it attaches itself necessarily to the issue of good faith. Whether or not there is a breach of that obligation, if somebody else participated in that obligation, certainly if he's a director, and it can be shown that it's as a result of a lack of diligence, there could be a liability there. Shareholders are a different story. I think that the threshold is even higher for those that practice in that area.
Question, if I may?
Go ahead.
Thank you. What about negotiations between attorneys? If there's a contractual aspect to it?
Well, I mean, negotiations between attorneys are governed by, are you talking about within the context of litigation or just between attorneys as they relate to a commercial contract?
Both, because of the civil code and because of the code of procedure.
Well, I mean, negotiations between counsel within the context of litigation answers to a whole body of.
I understand. No, I understand that. I understand. But we have a duty of good faith, apparently. That's much stronger than it used to be. I said apparently for a specific reason. That's what made you laugh. But the point is, if our duty is to be totally in good faith, hold on. If it's our duty to be totally in good faith at all times, is it not conceivable that another attorney can be either brought before the bar or sued for lack of good faith in the negotiations in the same fashion as the Supreme Court?
Well, I think that you're raising ethical concerns there. I think that
Not only ethical, but legal.
Attorney, yeah, and those, yeah, well, those concerns would be answered by the code of ethics and the statutory obligations that an attorney has to act properly, both vis-a-vis his client, but more importantly vis-a-vis the profession and colleagues, and that would certainly include an obligation not to engage in mindless or fruitless negotiations, or to act improperly, or to deceive or mislead a colleague. And in keeping with that, you know, when we're talking about negotiations having to do with settlement within the context of litigation, there is a caveat that allows a party to be able to claim damages from the other party in the event of an abuse, right? In the event of a negotiation. So even if there's no agreement,
Misinformation or lack of information.
well, it could take many forms, right? But I mean, to the extent that it rises to the level of abuse, even if there is no agreement, a party can, through his attorney, make reference to those negotiations for the purpose of establishing the abuse and therefore claim damages.
But the reason I asked the question is because the code seems to include in its new principle, new philosophy, a totally new juridical approach to the problems that they've been having in trying to get the number of cases down, and it's cooperation, et cetera, et cetera. Does that not give an even greater obligation to attorneys in these circumstances, even greater than the ethical ones in the ontology?
Well, the answer is I agree with you to the extent that, you know, for those of us that litigate, and I'm one of them, you know, we're living in this new world order where, you go to court, the judges, they're basically asking us, why can't you get along? Why haven't you worked this out? Why are you here dealing with this? Why are you insisting on that? So there is this message that continues to be pushed down to us, talking about the obligation of cooperation. And there's a whole slew, as I'm sure you're aware of judgments. I believe it's under 342 of the CPC and other articles condemning clients to pay damages as a result of improper or dilatory conduct on the part of the attorney. So yeah, there's an obligation of good faith generally. There's a statutory obligation to act properly pursuant to the code of ethics. And there is also this obligation to cooperate within the context of actions that are pending before the court. Absolutely. I think that there are different permutations and combinations of the same thing. I think a judge will simply look at the situation and decide for him or herself whether under the circumstances this is something that was reasonable or not. But I think that the principles are pretty much the same regardless of how you look at it.
Okay, thank you.
Anyone else? Go ahead. Don't be shy.
I have one probably fairly obvious question that you may have touched on throughout, but is this simply a codification of creating an equitable jurisdiction for the courts in Quebec?
Well, it's an interesting question, because when we look at the Churchill Falls judgment, it specifically seemed to want to exclude equity as being a sort of foot in the door to renegotiate or to do a retrade or whatnot. But I think that it forms part of this whole mantra of, have the parties acted properly under the circumstances. And I say this to you, and I say this to all my clients before I go to court. I have a number of partners that are on the bench. I have now turned 61 this year. I have friends that are on the bench, and they all tell me the same thing. For those of us that have people that on the bench, they listen to cases. And it's not that they rule on equity, but they listen to cases. They decide what they want to do, and then they sort of retrofit, right, depending on what the evidence is. And a lot of it has to do with what they feel, without talking about being a court of equity. I mean, obviously, you have to apply the rule of law as it applies to the facts. But I mean, it's in keeping with that type of mantra of what's right under the circumstances. So without talking about a court of equity, I think that definitely, in my view, it forms part of the cocktail. I think it's one of the things that the judge takes into consideration when deciding whether somebody acted properly, improperly, they're credible, they're not credible, they should have done this, they should have done that, they should have abstained, they should have informed, they shouldn't have done this, they exercised their rights too quickly. It's all part of the same thing. It's a bit hard, in my view, to draw the line between what would be conduct which is commensurate with good faith and something that would be otherwise inequitable as a jurisdiction, as we know it under the common law, in the traditional sense of it. But I think that they're all sort of, again, I think they're all permutations and combinations, a bit of the same concept of to do what's right under the circumstances, in keeping with obviously the contract that was signed and the parties' rights and obligations. But yeah, to do essentially what's right, and therefore equitably. Properly.
Do you think that there's any overriding principle under civil law that ought to be applied to avoid creating an equitable jurisdiction? It obviously, in contractual matters, it really shouldn't apply, other than some massaging or finesse that a judge can do to get the kind of decision the judge wants under the guise of contract law. But anything that's pre-contractual or post-contractual. And I ask this question because I imagine ultimately one day challenging one or more decisions of the courts that are effectively equitable, and going to all the way up to the Supreme Court to say this is ultra vires. You can't be making decisions that are not based on the civil law.
Well, I think that you have to sort of, and I touched on it before. I mean, off the top of my head, I would see it as two big groups of circumstances, if you will. People that are under contract, people that are not under contract, right? The ones that are under contract, it is whatever it is. And then the ones that are not under contract, there's that whole body of law, as I spoke about it before, about the obligation to act properly and in good faith. And I think that one would be hard pressed to go and to challenge that concept all the way, well, regardless, Superior Court, Court of Appeals, Supreme Court, on the basis that somehow the courts are importing a concept of equity, when, for example, in Churchill Falls, the court says it's not the case. And I think that it's very easy to use a French expression, de noyer le poisson dans l'eau, okay, and talk about concepts of good faith and duty to act fairly, which are analogous to equity, essentially. And to say, listen, we don't really need to deal with the issue of whether or not equity as a concept exists in civil law as a source of civil liability or otherwise. I think that there's more than enough for the courts to be able to come to the conclusion that yea or nay, there is a liability here, or there was improper conduct based on the concept and the general concept of good faith. And if you look at the cases, for those of you, it'd be my pleasure to send you the cases on the highlighted versions. I mean, they all say the same thing, right? It's, I said before, it's like nailing Jello to the wall. It's very hard. It's very hard. It depends on the circumstances. It depends on the party's conduct. A lot of it has to do with also perception and how the court would perceive a party's conduct to be fair or unfair. So it's a mishmash of a lot of stuff, but essentially it all gravitates around the same concept. So I'm not quite sure that it's to that point distinct that it would stand up to a challenge, in my view. But I don't have the robe with the red lines on them, so my opinion is worth as much as yours.
We have a few questions. I see Norm had his hand up. Norm, would you like to speak? Just unmute yourself.
Okay. My question has to do with like a common situation in real estate where somebody is looking to tie up a property, you know, with a sort of free option with no intention of buying it themselves, but they just feel like once they've tied it up, they'll shop it and see if they can flip it to someone. And if they can, they'll go through with the transaction. And if they can't, they'll just, you know, you've always got subject to clauses in a real estate offer. Is that acting in bad faith, or that's legitimate?
I mean, I would tend to say no, depending on whether or not the promise to purchase contains an assignability clause or not. I mean, if the rights under the promise can be assigned, I don't think that there's anything legally improper with somebody who's looking to buy a property and looking to flip the offer to somebody else. If I find out that my neighbor died and I decide to buy her duplex because her son lives in Vancouver and the other one lives in Nicaragua, and I buy it for 50% of the fair market value, I sign an offer to purchase and I decide to flip it to somebody else, and there's no provision that prevents me from doing it, I don't know that there's anything improper with that. Unless of course I've made representations to the vendor otherwise, and if I decide to walk away because, as you put it, a subject to clause or typically a due deal clause, then I don't see there being an issue there. If ultimately the buyer walks away and there's none of that, then and there's no right to walk away, then I think the vendor at that point in time would be able to make a claim for damages if there is any.
Let me clarify my question, please. You see, the standard offer would normally have a non-assignability clause in it, like you'd need permission of the vendor to assign it. And of course, if the vendor is willing to give it, what's the difference? But in a case where, and it's not uncommon, somebody will tie up a property, purportedly to do due diligence, but they have no intention of buying the property. They're just looking to get an option on it for free. In effect, they're acting almost like an agent because they will take possession. Like they'll sign the deed, they'll be the owner for a minute, and then they'll sign another deed selling it to someone else. So it's not an assignment, it's a purchase and then a sale. But they're only going to go through with the purchase if they line up someone to sell it to immediately. So, you know, now if obviously if they mentioned, like, I have my own people and this is what I'm going to do, and they're forthright, then of course it would be okay. But most of the time, this would be, you know, their own private knowledge. It wouldn't be transparent, obviously, until afterwards.
I mean, for me, there are two things. There would be the case where somebody's looking to tie up the property and does not go through with the sale, and was looking essentially to either do a back-to-back sale or to flip the offer, presuming that there isn't a non-assignability clause, right? Then clearly, I think there would be a breach of one's obligation of bad faith, because in this case, right, they're contracting with the vendor not really having the intention to buy. But in the case of somebody who signs a promise and has, for example, a 60 or 90-day due deal clause and goes around and shops because he wants to resell the property or wants to do a land assembly or knows that the neighbor is looking to buy and got his hands on the property before and turns around and sells it the day after having bought it, I don't think that person, in my view, barring any misrepresentation, but certainly in the absence of any representation to the vendor, I don't see why that person would be liable because they simply made a profit by flipping the property. Example, to the neighbor.
No, when the transaction goes through, I wouldn't think there's bad faith. Like once you buy a property, you could do anything you want, but tying it up for a few months and then saying, oh, well, forget it. I'm not going through with it on some pretext because they couldn't find someone to sell it.
That 100%, 100%, and the case law talks about that word pretext all over. That 100%, I agree with you. Under those circumstances, there would be liability on the part of the prospective purchaser. As far as I'm concerned, that's a clear breach of their obligation of good faith.
Okay, well, so ladies and gentlemen, that is a wrap. It's 1:30. I want to take this opportunity to thank Maître Samuel for a fantastic presentation that myself as a layperson, I was able to follow and understand, and also for Pamela for her invaluable assistance and the fantastic PowerPoint that made everything so clear. I want to thank you everyone for joining us, and we look forward to seeing you next Wednesday, same time, and you can use the same link. If you have colleagues that would like to sign up, just forward them the sign up link and they can join as well. Thank you everyone for joining us. Have a wonderful day. Someone asked about the PowerPoint being available. I think Pamela said it will be available. And also, if you have any other questions, if you want to keep chatting, that's up to Lois Samuel, but I think that we all have busy schedules today. I'm sure you can forward your emails to Pamela, who will make the PowerPoint available. She will send me her email address if anyone wants to have a copy of the PowerPoint. So thank you very much, everyone, for joining. Again, this is Deborah Shanowitz for Chabad Westmount Law Series, and have a wonderful week. Thank you.
Thank you, Louis.
Thank you.